general+Orange Air Ambulance and related services, and recommends the following. 1, that legal counsel not meet with any witness or witnesses counsel prior to their appearance before the Standing Committee on Public Accounts. 2, that when the committee clerk confirms a witness's appearance before committee, he will also state it would be inappropriate at these hearings to indicate that you have spoken to the police with respect to Orange. 3, that the committee requests that all hearings be held in Committee Room 151. 4, that the committee clerk, in consultation with the chair, be authorized prior to the adoption of the report of the subcommittee to commence making any preliminary arrangements necessary to facilitate the committee's proceeding. I move adoption of the report.
Any debate? All in agreement?
Agreed.
Agreed? Agreed. Okay, that report is carried. And our first witness this morning is Peter Wallace, Secretary of the Cabinet, Head of the Ontario Public Service. If you could please come before the committee. Yep. Welcome.
Thank you.
And clerk will have you do the oath.
Okay, so could you just raise your hand, Mr. Wallace? Do you solemnly affirm that the evidence you shall give to this committee touching the subject of the present inquiry shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. And we have 5 minutes for an opening statement, and then there will be about 8 minutes each for the various parties to ask questions. So please go ahead.
Thank you, and I'll be pleased to review my statement, and obviously pleased to answer any questions the committee may have. Good morning. I am Peter Wallace. I'm the Secretary of Cabinet and Head of the Ontario Public Service. I started my current position on December 17, 2001. Previous to that, I've been a public servant for approximately the last 30 years. Prior to my current appointment, I was the Deputy Minister of Finance and Secretary to Ontario's Treasury Board from September 2008. I've also had the opportunity to serve as Deputy Minister of Energy, Deputy Minister responsibility for policy in the Cabinet Office, as well as various positions with the Ministry of Natural Resources, Management Board, and other ministries. I'll focus my quite brief remarks on 3 technical areas that are under the purview of the Ministry of Finance and I believe may be of interest to this committee. These are public salary disclosure, the procedures associated with the consolidation of various entities into the province's reporting books, and the ministry's role with respect to internal audit and the internal audit process. Starting off with the Public Sector Disclosure Act. This is an act that is administered by the Ministry of Finance. The act, as I think the committee is aware, outlines a series of technical criteria and then in turn imposes an obligation on applicable organizations and individuals to disclose any compensation, essentially T4 compensation, over $100,000 level. The obligation is on the reporting entities. The information is collected through the line ministries, consolidated and published, made available by the Ontario Ministry of Finance. There is always some considerable year-to-year churn in the numbers as both individuals come on and off the list and as well as organizations appear or change status and are no longer eligible. Secondly, I'd like to talk about the consolidation of entities. I understand this has been an issue of some interest to the committee. To provide some background on this, in I think 2005, the Public Sector Accounting Board altered the accounting standards applicable to provincial governments. And this change in the accounting standards is largely a technical change, altered the reporting entity associated with the government of Ontario, and in fact considerably expanded the reporting entity. The consolidation change in criteria were essentially technical. They respect a view of an accounting construct. The act of consolidation, and in this case Orange was consolidated into the province's books earlier, does not change in any way the practical control of the organization. It doesn't. The fact that the organization is consolidated into the province's books doesn't change at all the practical governance mechanisms through which operational control is normally exercised. That's through performance agreements and other oversight arrangements. This is an important construct because as the construct of consolidation expanded dramatically in the middle of the last last decade, a large number of organizations have come onto the province's books as part of the consolidated entity, and these have historically exercised a very significant degree of operational independence from the province. So, as an example, hospitals, school boards, and organizations that function almost completely independently from the Government of Ontario, such as pension bodies, Healthcare of Ontario Pension Plan, for example, are technically consolidated into the province's books and are part of the reporting entity, although the province exercises no effective operational control over those entities, and the simple fact they're consolidated does not alter the controls. I think that's accurate, Auditor. I think that's my understanding.
Mr. Wallace.
Thank you. The third point I would like to cover is internal audit, which is a vital management function in the Ontario Public Service, and it's one we take extremely seriously. The Internal Audit Division is headed by an Assistant Deputy Minister who reports in to the Ministry of Finance, to the Deputy Minister of Finance, for administrative purposes. And there is a clear protocol, a clear understanding that the work of the Office of the Internal Auditor is not influenced or altered by the Deputy Minister of Finance. So the reporting of audit findings, the routine and non-routine activity of internal audit is not generally shared with the Deputy Minister of Finance. The reporting relationship is a consolidated one that facilitates a relatively efficient administrative relationship, but is not intended as an operational or policy relationship. Internal audit remains functionally independent, and this is an important construct. It's designed to be functionally independent from the guidance of the Deputy Minister of Finance. And in that context, the Deputy Minister of Finance would obviously not receive, as an ordinary course of business, reviews of specific audits of any type. Last point I'd like to cover is that, as the committee is aware, I was one of 14 individuals copied on a January 19th, 2011 letter from Ornge. Well, I have no recollection of receiving and reviewing the letter. A subsequent request was received by my office from Ornge asking for attendance at a meeting. I was not available for that meeting, but officials from the Ministry of Finance did attend a briefing provided by officials from Ornge. It is my understanding that this was primarily a technical conversation, that Ornge was showing the government what it had done in terms of a bond issue, and a handful of other points. The Ministry did review the material provided by Ornge, did engage in a technical conversation. The focus of the conversation, I am informed, was on the potential risk to the Ontario credit from the bond issue undertaken by Ornge. And obviously, from a Ministry of Finance perspective, any time you have a transaction occurring, any transaction, you'll want to undertake a certain amount of due diligence to be assured that that transaction does not expose the province's credit to any incremental both in Ornge, the January 19th letter, and in that subsequent meeting, to indicate that the province's credit was fully insulated from the bond activity undertaken by the entity. So that was a clear focus of the Ministry of Finance and the Ontario Financing Authority, was to ensure that the province remained insulated from any incremental risk.
If you don't mind wrapping up, we're a little.
I'll be happy to wrap up, and I will simply conclude by saying that I do remain obviously exceptionally concerned by the findings of the Auditor General. I am acutely aware of the need for the Government of Ontario to continuously drive for more efficient operating models, including operating models that are not traditional, that involve other groups into the delivery of public services, including core public services. But we must always, as the Auditor General report reminds us, remain absolutely vigilant to proper accountability structures, proper control structures, proper performance agreements, and other mechanisms. I'll be pleased to answer any questions the committee may have.
Thank you, and we'll move to the official opposition to begin with. Mr. Klees.
Thank you. Thank you, Mr. Wallace. I'd like to move quickly to the issue of the $300 million bond offering.
Yes.
And I find it interesting that you say that you were satisfied that there was, as you put it, that the credit of the province was fully insulated from any incremental risk. Can you share with us what did you rely on for that insulated risk?
I appreciate the question, and the reliance was not by me directly, but by officials from the Ministry of Finance, from whom I've obviously subsequently sought information. The meeting, as I understand it, and the correspondence from Ornge, as I understand it, refers retrospectively to bond issues that have already occurred. We have, in the Ontario Ministry of Finance and the Ontario Financing Authority, fairly substantial experience in bond issuance and in the relationship between bond issuance and organizations with which the Government of Ontario has some type of ongoing financial or other relationship. So we relied on, as I understand it, asked questions about three core areas. The first is the actual documentation provided to me through that letter, which articulates I believe provides a fair number of assurances that the activities being undertaken by Ornge were outside of, both consistent with the performance agreement and outside of the financial relationship with the province. So there's a clear written record that establishes that. The second part is that there was a series of questions or dialogue at the meeting that confirmed those written assurances. The third, and from a slightly more pragmatic perspective, is that this is an issue that had, as I understand it, already taken place. It had been reviewed, it had been placed on the market. The market would have seen in the documentation, would have been able to form a judgment that there was no provincial guarantee associated with that. And it would be my understanding from that this would be a reasonable level of oversight with that type of entity, given that the issue had already occurred.
Mr. Wallace, I'd like to ask this. Have you seen the offering memorandum that was used?
I have not reviewed the offering memorandum.
You have not. Did your ministry officials at any time review that offering memorandum, knowing that $300 million was being floated on the open market?
$300 million was being floated on the open market by an entity that we were given concrete assurances, and I appreciate the question, but $300 million was floated on the open market in response to a structure that insulated the province of Ontario. So what this means is that if Ornge defaulted on its obligations, or if the entity defaulted on its obligations, an unlikely but nevertheless scenario that needs to be considered, there is, as we understand it, no recourse back to the province's credit. That would be the primary concern from an Ontario Ministry of Finance perspective.
Mr. Wallace, I've read that offering memorandum. There are repeated references to the Government of Ontario, repeated references to the $150 million of revenue flowing directly to Ornge, repeated references to the security. In fact, the rating that was attached to this public offering relied almost exclusively on the fact that it was the Government of Ontario that was standing behind this offering. I find it quite disconcerting at best that we have such a major public offering taking place with the very clear guarantee of the Government of Ontario, and Ministry of Finance officials were not aware. Can I ask this? Was the Minister of Finance made aware that this offering was being floated before it was?
I apologize, but I need to spend a moment with the language you used. I discussed the notion of incremental exposure to the province's credit. The core construct, as I would understand it, and as the financial professionals would understand it, is whether or not, in the event of default, additional incremental obligations would accrue to the province. I, of course, have no understanding of the way in which rating agencies or investors would have made the decision. That is, frankly and fundamentally, their business, and any construct associated with that would be purely speculative on my part. I do know that the core issue in any bond relates to the security. There is no recourse, as we understand it, and we were given concrete assurances that there is no recourse back to the province's credit associated with any incremental obligation incurred by the entity. I apologize for exploring that, but I do need to answer your question. I do need to answer your question, which is I am not aware of any briefing to the Minister of Finance.
Okay. At the end of the day, is the province of Ontario now responsible for the $300 million that is out there in bonds? Is the province of Ontario now directly responsible for the interest payments and ultimately the repayment of the capital of that $300 million?
If the entity known as Ornge is unable to fulfill its financial obligations, which it occurred through a separately structured subsidiary transaction with bondholders who read and reviewed a prospectus, there is no incremental risk, I understand, from a legal construct to the province's credit. The entity, as I understand it, has not been altered by the very appropriate governance changes that have been put in to provide additional fiduciary oversight.
Mr. Wallace, anyone reading that offering memorandum will draw the conclusion that it is the province of Ontario that is standing behind that bond offering, that it's the $150 million of annual funding that will sustain that entity that issued, because there were no other assets. There was no other revenue in that entity that was floating those bonds. And so for anyone to accept that there would be no incremental risk to the province of Ontario is outrightly irresponsible. And my question to you is who at the Ministry of Finance will be held responsible for that?
Let me...
we have to move on, I'm afraid.
I will be clear.
Okay, go ahead and answer the question.
I will be clear. I was, through much of this period, the Deputy Minister of Finance. And if there is accountability associated with that, those accountabilities would rest with me as the Deputy Minister of Finance and as the Chair of the Ontario Financing Authority. I will say that in those roles, I have the opportunity and privilege to work with individuals, well known to Mr. McCarter and others, who are professionals in the world of corporate finance and the world of public finance. In that construct, we have considerable experience with the offering of credit facilities by a wide range of private, public, quasi-public entities. We have considerable experience with offerings by entities of the broader public sector that do in fact retain and attract risk back to the Government of Ontario. So while I appreciate your view and I appreciate your reading of the prospectus, we will, frankly and with respect, have undertaken a different understanding on the basis of a clear written document from the entity and on the basis of appropriate due diligence concerns. You may feel that investors would have had a different view. Our understanding legally, the assurances we sought, were that this was a separate, insulated entity. Doesn't mean we like it. Doesn't mean that it's something that is a best practice. Does mean that from the perspective of does this attract incremental legal risk, which is the appropriate standard when confronted with something that has already occurred, there was no, as we understand it, as we were assured, incremental risk. That structure remains intact. Bondholders do not have, and this would be an important legal issue, we would retain, and we believe would be accurate, that bondholders do not have direct access back into the provincial credit. This is also critically important from a broad policy perspective, because we continuously strive for mechanisms, for partnerships that make our business more efficient. As we strive for those, we do need access to private credit. Being able to maintain the distinction between private and public credit remains of vital importance. We do not put ourselves into the minds of potential readers of prospectuses. We put ourselves into the minds of the Government of Ontario. From a Government of Ontario perspective, with respect, we were assured, we understand factually, that there is adequate insulation from the province's credit.
Thank you very much. And if we can move to the NDP, Vance?
And make sure that I get my full 10 minutes.
Yes, you will.
First thing, good morning. The first thing I would like to know is when were you first made aware that Ornge had for-profit subsidiary?
I'm not cognizant of when I became aware of that. At the point at time in which information was presumably provided to me that would make me aware of it was the January memorandum. Unfortunately, I frankly have no recollection of that memorandum. It was actioned by my office, so it was quite lengthy and one of a fair number of copies. So I would have become more aware of it when media coverage and the Auditor General's review intensified, and it became a subject of more broader interest.
Okay, so can you give me a date as to when it became broader interest and it hit your radar?
No, I'm afraid I cannot.
A range of time? Was it just before Christmas? Was it last summer when the auditor started his work, actually was completing his work?
I would, if I'm forced to speculate as to a range of time, it would be someplace between January, late January, and let's say June of 2011. In terms of the specific question, which is the creation and mechanics of creation of a for-profit subsidiary, that's a fairly specific question. And,
no, I didn't ask that question. I asked, when did you become aware? So you became aware between January 2010 and 2011 and June of 2011. Did you speak to anybody about this when you became aware? Did it raise any red flag to you?
The simple existence of a subsidiary of any entity is frankly not uncommon.
So it didn't raise any red flag for you? When did it raise red flag for you? When did it become an issue for you?
The issue is frankly not one of corporate structure, but corporate behavior. And we have a wide range of organizations, and I appreciate the nature of the question, but it is vitally important that we, from an Ontario Public Service perspective, be open to finding better ways of delivering public services. It is not remotely uncommon for broader public sector institutions to create subsidiaries to try and extract value from other areas of public service activity. This is done routinely by other areas of the broader public sector. So the mere creation of a subsidiary or an entity would not, in the general rule,
but I'm
raise red
asking
flags.
you, when did it become an issue for you? Is Ornge an issue for you now?
Of course, Ornge is an
When
issue.
did it become an issue?
It presumably became an issue at the time when the question of the behavior of the corporation.
I'm looking for dates.
I'm afraid that I don't have the specific dates associated with that. I'm afraid that I do not keep a diary that indicates what dates I became aware of.
Give me a
issues.
range.
I believe I already have. I've said,
Okay, so
my
since
understanding.
2011. So when this became an issue, like you said, Ornge is an issue. It became an issue between January 2011 and June of 2011. Who did you speak to about this?
I would have spoken to officials in the Ministry of Finance. I would have
The minister himself?
I have no recollection of a specific conversation with the minister on this.
If something is an issue, wouldn't it be reasonable to assume that the Secretary of Cabinet talks to a minister? Do you talk to the minister ever?
I was the Secretary of Cabinet. Of course, I talked to the minister. I was the Secretary of Cabinet following December 11th. During most of the relevant time period, I was the Deputy Minister of Finance.
Did you talk to the Minister of Finance when you were Deputy Minister?
I talked to the
If
Minister of
something
Finance.
is an issue, would you talk to the minister about issues?
I generally do discuss issues with the Minister of Finance, yes.
So is it reasonable to assume that you talked to the Minister of Finance that there was an issue at Orange?
It is reasonable to assume that if there were specific issues that were raised with me that related to the responsibilities of the Ministry of Finance, if, for example, we had, information that did expose the province's credit or information that was different.
But you did say that you became aware between January 2011 and June 2011. You described it. You recognize that Orange is an issue. There was an issue. It is your job to let the minister know. So it is reasonable to assume that you talked to the Minister of Finance. Orange was an issue between January 2011 and June 2011.
I'm trying to be helpful here.
Yes,
but
Ms. Jelinek, if you can let him answer the question, please.
He's too long in his answer and tells me a whole bunch of things I don't want to know.
I'm trying to be helpful, and I apologize.
So the clock just stopped.
No point of privilege. Let's continue here.
I explained to you the time frame, and I explained to you my mechanism by which I became aware of this was information of public knowledge. Information of public knowledge, for example, that the Auditor General was conducting a review, I would have become aware of that, not through an internal audit mechanism, not through some other mechanism, but frankly, through the same mechanisms that others became aware of it, through allegations about corporate behavior.
Okay.
Those allegations about corporate behavior were broadly known, and I would not have felt compelled to share information broadly known specifically with the minister. I could reasonably assume that the minister would read the papers in the same way that I would read the papers.
Okay, I want to talk about disclosure, that the NDP file a Freedom of Access of Information about the lack of disclosure of Dr. Mazza's salary. The Freedom of Information went to your ministry, and basically we got back that they couldn't share anything with us. The fact that we file a Freedom of Access of Information, that we ask specifically what had happened to Dr. Mazza, would that have been flagged to you in any way?
I have no recollection of it being flagged. It would normally not be flagged, and I have no direct knowledge of that. But in general, the questions are phrased. We are under obligation. We take the obligations extremely seriously to provide any response of records. In this instance, there presumably would be no response of records. In the absence of response of records, we would send a response indicating that there are no records that we can disclose simply because we do not have that information.
Okay. We have a document called the Indicator of Control, dated 2008, from the Ministry of Finance that states, we feel the government can effectively govern the finance and operating policies of Orange. You were the Deputy Minister at the time.
Excuse me, Ms. Jelinek, do you have a copy of this document you're referring to?
It's in the newspaper.
It's in the newspaper.
So-
It's a quote from a newspaper. So,
So if the government members want to see it, then we need to be able to see
it's in the press clipping that was circulated to us when the good people did their work. Remember, they gave us a package of information about Orange?
So I'm going to stop the clock now because we're being interrupted.
So if it was in the legislative research package that was sent around, that's fine, continue.
Thank you.
Mr. Chair, I stopped the clock at 7:41. I'd like it to resume now and not have any of this time count against us.
Yes, I take care of the clock. Continue, please.
Thank you. Okay, so it basically document from the Ministry of Finance that says, we feel the government can effectively govern the financial and operating policies of Orange. You were the Deputy Minister at the time. Did you feel confident that you could govern the financial and operating policies of Orange?
Two constructs here. First, this preceded, as a technical point, preceded my appointment as the Deputy Minister of Finance, as I understand. Secondly, and far more fundamentally, the consolidation process occurred over a very large number of entities over a relatively accelerated period, a time at which we took entities such as hospitals, school boards, pension plans, a variety of others, and included them into the province's reporting entity. This was reflecting a set of technical accounting changes that changed the accounting definition of control. There was, in fact, no...
We are out of time. I would just let all the members know that if you're finding you don't have enough time, you do have the ability to call a witness back at a future time. So we are out of time now. If we can move to the government, please.
I would like to be helpful on this point,
Yes.
if I can.
You know, these proceedings are difficult enough, given the limited time frame that we have. The constant interruptions by members of the government committee members here, I would ask that we have an agreement that you as the chair have the responsibility to ensure that these proceedings are carried out in a way that is appropriate. We don't need either Mr. Zimmer or Ms. Sandals acting as referee. And I would ask you as the chair
I have the
to take
ability
control
to do
of
that.
this
Thank
committee.
you very much. And in the interest of time, we will...
Memo from the council just on Mr. Klees' point. The council addressed how the procedure...
I think
This
that's...
That's Mr. Zimmer, that's
All right, well,
privileged
then I
member,
ask-
so please don't refer to it.
I
If we
ask
can-
you to look at page 6 on the procedures for members if they object to a question and the procedures that we have to follow. It's at page 6 of council's memo.
We know about that, and now if we can proceed to the government, who would like to do the questioning on the government side?
Yes.
Ms. Sandals.
Thank you very much, and I appreciate your patience and your very clear answers. And forgive me if I refer to you as deputy, because that's how I'm accustomed to it. But we seem to all be taking advantage of your knowledge as Deputy Minister of Finance. And I wonder if we could go back to the issue of consolidation, which is very complicated, and if you could explain to us, A, is Orange consolidated on the province's books, and B, why is Orange consolidated on the province's books, and at what time did that become, when did that happen? What's the consequence of that happening?
Thank you. I'm going to treat it, frankly, as an extension of the last question, and try and be helpful in terms of I think, the intent of the past question as well. Consolidation is an accounting construct by which an entity is brought into the reporting another entity's reporting books. It's used in a variety of subsidiary contexts. It's used in a variety of others. In 2005, the Public Sector Accounting Board, which is what sets the standards for provincial governments, broadened the standards, altered the standards to broaden the number of consolidated entities. As part of that, there has been a fairly extensive conversation that involves the Office of Controller in the Ministry of Finance, line ministries, from time to time, the Office of the Auditor General, in understanding the application of these new standards. The application of the standards themselves and the shift in the standards is of no practical consequence in terms of the reporting relationship, oversight, or other aspects. This is not by any way of an excuse, just simply that consolidation as it exists in a reporting entity construct is not an indicator of anything else. And for example, we have no visibility, no reporting relationship, no visibility into the corporate structures or governance or other mechanisms used by pension boards, as an example, nor would we regulatorily want to have that type of relationship. In the specifics of the situation of Orange, while this occurred prior to my appointment as deputy, I understand it to have been a bit of a gray area, and I think probably that the Auditor General may be of help in this. That there are arguments that speak to consolidation of Orange in this construct, and they include the very high proportion of funding that Orange derives from the Government of Ontario. The fact that it is, for practical purposes, almost completely reliant on Government of Ontario funding. That is one set of criteria. There are other criteria that are used in the PSAB documentation that speak, for example, to the right to appoint a board of directors and other mechanisms. So we have universities that are largely funded by the Government of Ontario but excluded, hospitals that are largely funded by the Government of Ontario but included. The subtlety relates to the specific acts, the specific points around the right to appoint boards of directors and others. It's not a no-brainer conversation. It's not remotely surprising. In fact, it's normal to see differences of opinion about whether or not an entity is consolidated or not. In this case, the entity was deemed to be consolidated. The arguments on one side were seen ultimately to be a little bit stronger than the arguments on the other side. That decision is made in general by the Office of the Controller in the Ministry of Finance after consultation with others, including the Office of the Auditor General. And I realize that it is, tempting and I think logical to understand that this represents a shift or represents the acquisition of broader responsibility for an entity, and there are other reasons to be concerned about the government's responsibility for Orange. I'm not taking this away from the point at all, but it is not something that relates to the mere fact of consolidation. And I think, Auditor, I'm within the zone of accurate on that.
I think that summarizes it pretty good. You asked about the date, too. It was consolidated for the financial statements for the year ended March 31st, 2008. So the decision to consolidate was probably made sometime, I'm guessing, early to mid-2007 to consolidate Orange.
Okay, thank you. And then just one follow-up question. I take it from what you've said then that that it's perfectly normal to be having a discussion between the Ministry of Finance, the Controller, and the Auditor General and the entity itself about whether or not it should be consolidated and how that should happen, that as we've moved into the PSAB rules, that this conversation around what and how and when to consolidate is a pretty normal conversation.
It has occurred countless times. There are often differences of opinion reflecting different senses of the criteria. Initially, organizations are often surprised to learn that they may be consolidated. They generally are not, from time to time, uncomfortable with that concept until they understand that it is simply inclusion in the performance in the reporting entity and is, from a governance standpoint, of no practical ramification.
Okay. And if we could turn to your current role as Secretary of Cabinet, I believe you said you were appointed Secretary of Cabinet on December the 11th. What would your larger role then in dealing with the larger issues around Orange rather than, and I'm thinking here of the governance issues, how has that evolved since you have become Secretary of Cabinet? What changes have occurred since then?
So it was December 17th, I recall. That's a small adjustment.
Oh, okay, sorry.
Not especially relevant. In any organization that is as large as the Government of Ontario, in fact, in almost any organization, there is always some real risk of inappropriate behavior. That can occur within the organization. It can occur with transfer payment partners. It can occur with corporate entities with which we have a relationship. The two issues that are most vitally important on this are vigilance, understanding what we've done to mitigate risk, and learning going forward from any risk that was realized. We have to recognize that as government gets smaller, and we are a government that is getting smaller, we are looking forward to occupying a smaller share of gross domestic product than we have in the past. We are committed to efficiency. That will mean doing business in a very different way. And the risks we are exposed to in a large, bureaucratically structured hierarchical organization are very different than the risks we accept when we enter into more complex, sometimes more efficient, hopefully more efficient relationships with other service providers. It is kind of absolutely critical that we become alive to and increasingly vigilant about the nature of transactions, that we perform, that we undertake adequate due diligence, and that we have effective control, and that the use of taxpayer resources must be subject to adequate protections, so that if we do become concerned on the basis of any information whatsoever that an entity of any description may be behaving inappropriately, we have powerful mechanisms and powerful tools, audit, decision rights, governance changes, that will allow us to put those issues to rest as quickly as possible, and that we are not at risk of any type of behavior that delays or obfuscates or imposes additional timing issues for decision makers.
And we are out of time now.
Just one point, Chair.
Yes, go ahead.
Mr. Klees mentioned having possession of the offering memorandum on the bond issue from Orange. I wonder if that could be tabled.
Mr. Klees, do you mind tabling that?
I think Ms. Sandals can get it from the library in the same way that I did.
Okay, well, thank you very much, Mr. Wallace, for your presentation. Appreciate it. And now I'd like to call Alfred Apps forward, please.
Good morning, Mr. Chairman.
Morning, Mr. Apps, and we'll begin with an oath.
So the Bible's at the table there with you. Do you solemnly swear that the evidence you shall give to this committee touching the subject of the present inquiry shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And just to confirm that you received the notice to witnesses appearing before the committee.
I did, thank you.
Thank you very much, and you have 5 minutes for an opening statement, and then we'll begin with the NDP with the first round of questions.
Mr. Chairman, honorable members, I'm pleased to have this opportunity to appear before this committee in relation to your inquiry into Orange. Your job is to get at the truth, and I'm in a position to assist you. For the public interest to be well served, my presentation and your interrogation of me should take much longer and be much more detailed than 30 minutes allow. Serious issues of public policy and public administration are at stake. Vitally important questions of justice and reputation where individuals are concerned are also at stake. I'm happy to answer your questions today, and I will return in future frequently, as long, as often as you desire. This is important public business. On conclusion of these brief opening remarks, I will circulate a summary of my personal and professional background, as well as a detailed overview of the legal work I did in relation to Orange, so that you'll be in a better position to contextualize and evaluate my testimony. Like each one of the many professionals from the many legal, financial, and accounting firms involved with Orange, my ability to respond in recent weeks to the seemingly endless string of allegations in the media has been severely circumscribed by professional duties of confidentiality to Orange, and because I and my colleagues are lawyers, by Orange's right to claim privilege in relation to its communications to us and our advice to Orange. You've convened these hearings, and Orange has now waived those rights. This is fitting and appropriate. The government and people of Ontario have every right to learn the truth about what the legal, accounting, investment banking, and other financial professionals did for Orange on behalf of Orange and why we did it. I do not have the personal knowledge required to address certain matters. My exposure to Orange as a lawyer began in 2007, was intermittent, and focused on specialized work related to corporate structuring and structured finance. The original separation and establishment of Orange and the original setup of its charitable foundations and for-profit subsidiaries preceded my involvement. I cannot speak with direct knowledge about the total compensation of management or how it was paid. I was not made aware of any management loans until after they'd occurred. I was not involved in providing advice on salary disclosure under the Sunshine Laws. I was aware of the marketing services agreement with Augusta Westland, and based upon what I understood, saw absolutely nothing inappropriate about it. But I did not advise on it, play any role in negotiating it, and was not involved in documenting it. For the record, I also want to be clear that I have no knowledge of any wrongdoing, criminal or otherwise, in respect of anyone associated with Ornge. Let me provide a very brief overview of 5 key matters I can address. 1, the government entity reporting discussion, which the Secretary of Cabinet just so capably addressed, of 2007-8, has been characterized as a matter related to the government's substantive oversight and control of Ornge. This is a red herring. Nothing could be further from the truth. Ornge's financial statements, including in respect of its for-profit subsidiaries, were always audited by KMG, provided to the government, and included in the public accounts. The debate was never about substantive consolidation. It was about accounting consolidation only, and there is a huge difference. Ornge had always presented and audited its financial statements as a non-share capital corporation, charity, as it was required to do. Consolidation required its financial statements to be presented in a second and additional format to comply with the special accounting policies of government entities. Ornge was advised, or we at Faskins rather, were advised that the extra bookkeeping, reporting, and professional accounting services required going to cost Ornge significant dollars that would have to be diverted away from patient services. Ornge's only objective in questioning the need for accounting consolidation was to avoid unnecessarily wasting taxpayers' money, because it believed that the relevant accounting policy, which was open debate, if properly applied to Ornge, did not require such consolidation. Ornge nevertheless complied with the request, and accounting consolidation has continued to this day. The extra costs have been incurred for several years, but to be clear, accounting consolidation has done nothing substantive other than increase Ornge's costs. It contributes absolutely nothing to increased disclosure, enhance oversight, or government control. Number 2, the $275 million 2009 bond issue. This has been characterized by some in the media as something which was prejudicial to taxpayers because it enabled Ornge to apply funds to improper purposes and for the benefit of private interests. It has even been hinted that it was improper for Ornge to use public funding to service those bonds. These interpretations are patently wrong. They reflect a misunderstanding on basic matters of corporate finance. Ornge is engaged in a capital-intensive business with a serious cost of capital challenge. It requires aircraft, vehicles, and ground assets to provide its services to Ontario. In deciding to purchase its capital assets...
Your statement.
Sorry?
1 minute left for your statement.
In deciding to purchase its capital assets with low-cost rated debt financing rather than leasing them from third parties at a considerable markup or profit to those third parties, Ornge was able to significantly reduce its cost of capital over the long term, generating considerable savings for its operations for years to come. The financing was entirely standard in format, conventional in structure for transactions of this sort. It was clearly and only in the interest of the taxpayers of Ontario. With more time, I would be happy to elaborate. The government was fully informed before the bond financing was undertaken and raised no objections. 3, the 2011 reorganization leading to the establishment of the for-profit businesses under Ornge Global has been completely misunderstood and misconstrued, both by the press and the Auditor General. The for-profit structure was created to serve 2 primary purposes: insulating and protecting Ornge and Ontario and its taxpayers from new venture risk, and attracting private capital required to finance these ventures that Ontario clearly supported but did not want Ornge to vest taxpayer dollars in. The structure was not in any sense a private empire or conglomerate or web of companies designed to reward private interests. I'm probably out of time. I've got another page on this.
Yes, Mr. Zimmer.
I wonder if the
Quickly,
committee
please.
would consider, Mr. App said he had 5 points he wanted to address in his summary, whether we might, if I make the motion, to allow him to continue through
Mr.
his
Zimmer,
points.
why don't we just let him continue? And
I've got
finish
one
his
page left.
Finish your page,
Yeah.
please.
Okay, the structure was not in any sense a private empire or conglomerate or web of companies designed to reward private interests of Ornge management. It was a conventional, bankruptcy remote, private equity limited partnership investment structure that those experienced in private equity investment would easily recognize and understand as commonplace. and one that put management's upside incentive, clearly I want you to understand this, dead last, not first. The province of Ontario and the investors would have received $65 million before the management got a cent. Any potential benefits flowing to management were performance-based, highly contingent, and deeply subordinated to the interests of the Ontario taxpayer and the private sector providers of debt and equity capital. With more time, I'd be happy to elaborate. The government was thoroughly informed in respect of this reorganization before it was completed and raised no objections in respect of it. 4, the credit lease transaction of 2011 in respect of Orange's head office property has likewise been misunderstood and misconstrued by both the press and the Auditor General. It did not siphon money away from taxpayers to benefit the private interests who owned the for-profit companies, nor was it unusual or mysterious. In fact, transactions just like this are concluded every day in the marketplace by companies of all sorts for compelling reasons that I would be pleased to elaborate on. Analogies are never perfect. In fact, this is not perfect at all. But from a layman's perspective, it wasn't much different than increasing your mortgage to finance sending your kids to college. Importantly, the transaction was based entirely on an independent opinion about fair market rental rates from a leading national accounting and financial advisory firm, PricewaterhouseCoopers, something that has never been reported in the media and, curiously, was casually dismissed by the Auditor General. The credit lease transaction was a financing designed to benefit Ontario taxpayers, not harm them. With more time, I'd be happy to elaborate. The government was thoroughly informed in advance of the transaction and the use of proceeds and raised no objections. 5, and finally, it has been said that Ornge and its lawyers, including me, misled the minister and the government. This, you will understand, is offensive in the extreme, particularly for someone of my personal background, my long history of civic engagement, and my hard-earned professional reputation. The record actually speaks for itself. To the extent of all matters within my knowledge, the board and management of Ornge more than did their job, and the government was thoroughly, painstakingly, and in all cases, truthfully briefed in advance of Ornge taking any of these actions. If the government had ever raised any objections to anything, I am confident that Ornge would not have proceeded. Ornge was a great Ontario company with an extraordinary global future. It has now become a case study in the failure of public administration, not in my opinion, and it is my opinion, as a result of lack of transparency, process, or governance on Ornge's part, or frankly, from any lack of oversight or control on the part of the government, but as a result of the fundamental absence within parts of the public sector of the required skill set and competence in commercial and legal matters to properly understand and manage public-private partnerships. Unless and until we get this right, necessary efforts to offload funding from the taxpayer to the private sector will be met with misunderstanding and confusion, and as such become politicized and unable to attract investment and doomed to failure. There are excellent examples of success in this area right here in Ontario that we need to apply more broadly. Thank you for your attention. I would be pleased to take your questions.
Thank you, and we'll move to the NDP. Who in the NDP would like to question? Okay, Jacques?
I'll begin, yes. Thank you very much, Mr. Apps. Mr. Apps, so what specifically, if you could just highlight some very, very succinct issues, what was the problem with Ornge, and what's the issues concerning Ornge?
The only issue, and I don't have the competence to address it, that I have seen, based on all of my reading of all of the newspaper and my knowing the facts as I know them, the only issue is the salary that was paid and whether or not that was appropriate. Because everything else I've read is frankly wrong.
So now, you indicated that the government was thoroughly briefed on every aspect of Ornge throughout, before any step was taken.
Correct.
And how do you know that?
Because I participated in those briefings as a lawyer, advising, reporting on the structure, how Ornge was insulated, what the rating agency thought of the structure, and in fact, what we did in terms of structure was proven out. When the whole thing was blown up, the one thing that was preserved was Ornge, Ontario, with its rating reaffirmed, without impairment.
So who did...
So the point is, what we focused on was explaining to the government why that would happen under any scenario and why it was insulated from venture risk.
So you indicated that you'd briefed the government and you were present during those briefings. Who did you brief and who was present?
Oh, I've got a detailed record of every briefing that I participated in.
Would you be able to just...
I can just give you a high-level overview, and if you want more detail, I'm happy to give it.
Would you be able to table that?
Sure.
That detailed
It's a table. Yeah, I'm happy to table it.
And it's a document form?
Yeah, and actually, the summary that I'm going to circulate of what the legal work I did for Orange actually describes all the points at which the government was briefed. It's about a 6-page summary.
Thank you. And with respect to, you've heard the allegations that that there was some misconduct on your behalf, that you misled. I mean, what areas? It seems that you were thrown under the bus a bit on that.
You know, I think the minister is justifiably felt misled, but not by Orange.
Who was she misled by?
I believe that the draft report tabled by the Auditor General in November was so riddled with error and confusion that if I'd been the minister and I had gotten it and relied on it, I would have had the same reaction when coupled with the information about the salary.
Okay. Thank you.
France?
So it's rather interesting to hear you say that the only issue, in your view, with Orange is the salary paid, I take it, to Mr. Mazza.
Okay. I don't know anything about salaries, but I learned about the salary. And I'm not an employment lawyer. I was aware of what his base salary was. I wasn't aware of all this other stuff. It kind of hit me like a ton of bricks until I had the opportunity to think about it and reflect it. But I learned about it at the time it became public knowledge.
You were aware of his base salary, and what was that?
Well, I'm not aware of what his base salary was in 2010, but in 2011, and I'm not sure I've got my years right, so forgive me because I've got the document right in front of me, but it was $500,000, which didn't seem to me, given the extraordinary work he was doing, it didn't seem to me out of line at all.
Okay. Now that you know that it's 1.4 million, any comments?
I'm not competent to respond to that question. I wasn't involved. I understand that the board had outside compensation experts advising them, I'm not going to try to substitute my business judgment for theirs because I wasn't there or part of the discussions. So I don't really have an opinion on that.
Okay. In your briefing, was the Premier ever present when you briefed the government about Orange?
No elected politicians were ever present in any briefing.
And was this by design, or have you ever asked?
We made it clear, or Orange made it clear, and with my assistance, made it clear that we wanted to brief the government. We wanted to brief it broadly. Finance, health, education, or economic development and trade, Ontario Financing Authority. And we obviously left it to the government to decide who should go to those briefings.
Okay, so if you never briefed any elected official when you briefed the government about Orange, did you ever talk to any elected official about Orange?
No.
Never?
Never. Well, at a cocktail party, I actually had a chat after the bond issue with the Minister of Finance saying how successful the bond issue had gone, but that was it.
That was the only time you ever talked?
I've never met with the Premier on this, or his staff. I've never met with the Minister of Health on this. I've never met with the Minister of Economic Development and Trade on this. The answer is no.
Okay. Did you ever talk to any of the staff in their office?
Only yes, only in relation to setting up briefings.
Okay. So when Jameson Stevie says that you called him to...
I've read Jameson's testimony. It's absolutely correct. We never talked about substance. My question was, so there's a lot of happening here. They want to brief the government. And what's the right way to go about it? Should it be a common briefing, including of members, or should it? I can't remember the exact terms of the email. And his response back was, "Start with health, and we'll go from there."
And you have 2 minutes.
Okay. when you first learned that, when did you first learn that salary disclosure had not been done from Orange?
It was never part of my work. I wasn't, I mean, I did know they weren't disclosing their salaries, but it wasn't something, I don't remember when I would have actually become aware of that.
Is this something that you would have raised with Orange?
No, nowhere near my area of activity or responsibility.
So you didn't care?
No. Faskins wasn't the Employment or Labor Council and I wasn't the lawyer at Faskins who advised on this question. Others did.
How much money did Faskin made from Orange?
Well, this may surprise you, but I was not the billing partner or the relationship responsible partner for the file. I was actually just a guy who came in on the specialty team to deal with issues of my area of expertise. I have no reason to believe that what's been reported in the press is in general inaccurate, although I think there were lots of related inaccuracies, because I think those numbers were provided to Orange. But I can't get into the detail of it, except to say that that was for a very broad range of work, which mine was a subset, over a, I think, 6-year period, in circumstances where Orange had been extraordinarily active on a number of fronts as it got itself up and running.
Did Chris Mazza ever attend Liberal fundraisers when you were there? Or are you aware?
I have no idea. I would like, may I elaborate on my relationship with Dr. Mazza?
Sure.
Because it's been...
You have a minute left.
Okay, well, it's been fundamentally misdescribed in the press. He was like any other corporate CEO of a client. We had a friendly, courteous, and professional relationship. We were not close. There were extended periods of time when we had no contact. Normal, not the way it has been characterized in the media.
How much money did you make from Orange?
I'm glad to clarify that too, because the Toronto Star suggested I was a partner of Fasken Martineau at the applicable time, and I wasn't. Because I had been elected president of the Liberal Party of Canada, I withdrew from the partnership. I became a salaried employee of the firm with no stake in its fees. More importantly, Orange was not, I said I wasn't the responsible partner or the billing partner.
Looking for an amount.
Would you want to know how much I earned?
How much
As
did
a
you
salary?
make from Orange?
Personally?
Yes.
Nothing, zero.
You were never paid?
No, the firm was paid, and I earned a salary at the firm. But I wasn't a partner of the firm. I wasn't paid on the basis of Orange billings. I had my own practice, my own clients, my own billings, and I was, prior to withdrawing from the partnership in 2009, I was compensated in accordance with my financial performance on that. After that, I went on a salary because it was inappropriate for me, in my judgment, to be both the President of the Liberal Party of Canada and a partner of the firm.
Thank you very much. If we can move to the government members.
Yes, thank you. Could we go back to the compensation issue? Because leaving aside the 1.4 million figure and how you got from 500,000 to 1.4 million going out the door, the question that seems very odd to me as not a corporate lawyer is, if Orange is sort of the umbrella, Orange the not-for-profit is the umbrella, and Mazza and some of the others were the seniors executives there, is it not unusual to move the salary away from the senior corporation?
I'm going to be blunt. I am not knowledgeable in this area of law, and I'm not going to give you an opinion. That work was done by a completely different set at Faskins, and it actually, I think, was done even before I was involved. So it's not, I've never looked at the statute. I don't understand how the statute applies. I don't know what the circumstances were at the time, and I never advised on it.
Okay, so in that case, you've said that you weren't the responsible partner.
Right.
Can you share with us who was?
Yeah, certainly. I'll share anything you want. For a significant, the responsible partner, I don't know the exact dates or details, but it shifted back and forth. Originally, it was a retired partner before the separation who was on for Sunnybrook named George Glover. Then I think for a period it was Lynn Golding, who has played a very, I think, she has been counsel on a number of matters through the piece and done outstanding work for Ornge. Then it was Cindy Hines, and Ornge, because it was trying to reduce its legal fees, brought her in-house.
So she eventually went from Faskins to Ornge as a direct in-house.
Because she was the one who was principally responsible for what I would say the ongoing day-to-day operational advice, commercial law generally, so, you know, routine agreements, health law issues, regulatory law issues, and as a cost-saving strategy, at least as I understood it, they asked her to come in-house so that they could reduce their legal fees.
Okay. And who would currently then be the responsible partner?
Well, as you know, I left the firm, and I'm not certain I can answer that question.
So we'll have to ask Lynn Golding.
Yeah.
So, and then you also spoke to the issue of the billing partner. Would that be different from the responsible partner?
It depends. The responsible partner is sometimes the billing partner, but in some, and I'm just talking about internal practice at Fasken Martineau, sometimes the billing partner is someone who is not the overall relationship partner, but someone who's billing in certain areas because, you know, for whatever complexity or technical reasons, they want to make sure that they review and sign off on the bills.
So would the responsible partner oversee the billing partner?
Yes. But in most cases, the responsible partner is the billing partner.
Okay. And then you referred to the fact that you weren't the expert when it came to human resources and employment issues.
No.
Who would have been the partner who was responsible for the HR and compensation sort of negotiations?
On employment and labor law issues with Ornge, because Ornge had unions as well, we didn't act. That was Hicks Morley. But on the issues of compliance...
So Hicks Morley would have done the management side labor negotiations.
Look, all I know is that we weren't involved. I know that Hicks Morley were generally involved as employment and labor counsel to Ornge. I can't speak for what they did or didn't do.
Okay.
You know, on the issue of regulatory compliance, that is, issue of compliance and salary disclosure, that was something we advised on.
And that would have been which partner?
Mr. Guy Journo.
And I know that my colleague has some questions.
Mr. Zimmer, go ahead, and you have the 3.5 minutes.
Are you in a position to say why you left the firm?
Absolutely. I had intended to leave the firm in June of last year on the expiry of my term as President of the Liberal Party of Canada, and in connection with that, I had taken on several board positions at Pacific Mortgage as chairman, at Byron Capital as chairman, and several other boards as a director. As part of a partner in a big firm, it is a problematic thing to be on the board of clients. And I had decided that I was enjoying that, and I wanted to move out. But then the election came, the federal election came. The convention got delayed till January, and it just made sense to do it then after I stepped down in January at the fiscal year end of Faskins, which was January 31st. But I started talking to firms about what I was thinking about and where I was going to go, and ultimately I decided to go to a 45-person law firm that I helped to found 25 years ago. It used to be called Wildeboer Apps. My brother is there. I know many of the partners, and I have the freedom there to both practice law and serve on boards. But it was a decision of long standing that got upended by the federal election.
Thank you.
Okay. Thank you very much, and we'll now move to the PC party. Oh, do you have any other questions? You have 2 minutes.
The other issue I would want to raise that I think the committee needs to deal with is that Mr. Apps mentioned tabling documents, so can we just put an asterisk around a conversation with council way tabling documents?
Sure. Yes, and I believe Will's noted the documents that are to be tabled. And any other questions from the government members? No? Okay, we'll move to the official opposition. Mr. Klees.
Thank you, Chair. Mr. Apps, a bold defense of Orange you've just given us, an indictment of the government. You've made bureaucrats look like village idiots. You've undermined the Auditor General here in your comments. It seems the only people who know what they're doing is you and the professionals and the financiers who put the deal together.
Absolutely incorrect. There's great expertise in this government. There's outstanding expertise at Infrastructure Ontario in managing public-private partnerships. There's outstanding expertise at the Ontario Financing Authority. These are people who have developed the skill sets to understand capital markets issues, investment banking issues, and structuring issues. I would not be condemning bureaucrats generally.
I think if you take the time to read the Hansard record, you'll realize who you threw under the bus. But nevertheless, you acted on behalf of Orange, I understand, in the capacity of lawyer, advisor, spokesperson, and a lobbyist.
Mm-hmm.
Did you register as a lobbyist?
I never lobbied.
You never lobbied?
Not once.
You just said you did.
No, I didn't.
Okay.
I have never lobbied this government for anything in respect of Orange.
How do you define lobbying?
It's defined in the Act. Do you want me to get the statute?
You did nothing that comes close to lobbying?
Nothing.
Did you ever arrange meetings with elected officials for Dr. Mazza?
No.
I have a memo here from you, directed to Dr. Chris Mazza. And I'm happy to pass it around. Clerk? Okay.
Yes.
It is from Alfred Apps on Fasken Martineau letterhead. Talking points for Dr. Chris Mazza. Lunch with Minister Smitherman. And it goes on providing Dr. Mazza with considerable detailed direction in terms of what he can and cannot say during his lunch with the minister. Did you arrange that lunch with the minister?
I don't believe I did.
Okay.
Sorry, do you have evidence that I did?
I'm asking you.
No, we're talking, what time frame is this?
Well, it's your memo.
Well, Smitherman was the minister, so it's years ago. You can forgive me that my recollection isn't
Okay, fair enough. My question to you, you
but
mentioned that you never had discussions with the Premier on this. In point number 10, you say you advised Dr. Mazza...
I don't have point number 10.
You advise Dr. Mazza, my advice, and I'm quoting, downplay meeting with the Premier, perhaps not even mention it at all. You happened casually to meet him at a reception last month and had a general chat about successful transition at Orange. Interesting instructions, and in the last, on the last point, number 11, I trust you have that, I will call you separately this morning to report on contact with the minister. Now, you clearly said earlier that you never met with elected officials. Can you explain the difference between what you've told us and what is explicit in this memo?
I know that the contact with the minister was not personal contact of mine, but this, when did Minister Smitherman finish his term as Minister of Health? In any event, this is a long time ago, and I'm happy to undertake to you, Mr. Klees, to go back through my records and get back to you with whatever it is I was referring to there.
Thank you. I appreciate that. I understand that you introduced Don Guy to Orange. What was the purpose for you making that introduction?
Actually, it was at the time of the consolidation discussion. We that Peter Wallace was going over and that I mentioned in my thing. And it was related, so there were actually 2 periods which we sought Don's advice with, he was out of government by this time, had his own consulting firm. There were 2 periods we sought Don's advice and assistance, basically brainstorming, a brainstorming process to make sure that we were anticipating and thinking about the issues from the government's perspective appropriately. It was really trying to understand what the stakeholder perspective would be. And Don had a very broad overview of the thinking of government, and he was very helpful in providing us the benefit of his judgment and his advice.
Through whom did Don Guy bill his time for his lobbying?
Through Fasken Martineau.
Okay, and how much was he paid for that?
I wasn't a billing lawyer, so I don't know.
Would it be possible for you to...
Can you ask Ms. Golding to I can't undertake on behalf of Fasken Martineau anymore.
Okay.
But I know that Ms. Golding will be cooperative.
Now, you did mention that it was at the time of the consolidation.
That was the first stretch, and then there was a later stretch.
Right. Now, the information that we have is that the initial move on the part of the government to consolidate Ornge's financials was proposed by Ministry of Finance bureaucrats. And I also understand, maybe you can confirm this, that the reason that you brought Don Guy on board was to help fend off that attempt by the ministry to consolidate because you were going into this bond offering and you didn't want to have any interference. Is that correct?
Absolutely not.
And there's
Can I respond in detail on this point? Because I think it's okay. In fact, Ornge contacted me to say we're going to have somewhere between $500,000 and $1 million of additional costs. Is there anything we can do about this? I pulled out the Public Sector Accounting Board Policy 1300, took a look at it, and realized that this was really a gray area in the case of Ornge. It wouldn't be if the new legislation were enacted, which establishes so much tighter control. It would not be a gray area anymore at all. But at the time, it was a very big gray area. So it seemed that it was worth some investment to determine whether or not this had to occur. And I got involved with Ornge's consent, a top public sector accounting guy from PricewaterhouseCoopers on the technical issues, together with me, the CFO of Ornge, and Don Guy on the policy issues. And really, what Don Guy's advice was, and I make the point earlier, it was a red herring. It had nothing to do with the debt issue. And in fact, the government at the time, in a letter, made clear to us that consolidation or no consolidation wouldn't impact our ability to issue the bonds. So that wasn't the issue. But what Don Guy was able to do was actually persuade us, don't die on this hill. It's totally, I've got a sense of what the government's about here. And why they want to do it, and it doesn't have any impact anyway. And ultimately, that's what we concluded, even though it did have a cost impact.
So he was actually successful in managing away the government's concerns here.
For Ornge,
Yeah.
he was successful in helping me explain to Ornge why consolidation was not actually even a significant issue from a substantive or governance or independence perspective.
And we're out of time, I'm afraid.
We will certainly have you back.
I'd love to come back.
And what you have effectively done today is confirmed that the government of Ontario was fully informed of everything that Ornge was undertaking, including the bond offering, the scheme of for-profit companies. They were fully apprised, fully briefed, and did it anyway.
And they made the right policy decision in any event, and I'm sorry that they got bad information and advice later.
Thank you very much for your presentation this morning, Mr. Adams.
Thank you, Mr. Chairman.
And we have this morning been a little bit behind schedule, so the committee will need to decide on whether there's enough time to start with Mr. Shorthill. If we did, we only have 9 minutes, so I would suggest that that we reschedule Mr. Shorthill and apologize to him. I'd like to apologize to Mr. Shorthill because he is twice. This is the second time he's made arrangements to come before the committee. Well, thank you, and
I've lost track of, I thought there was some reference to tabling documents. Are there any documents being tabled, or?
There was one document that is going to be tabled to us. He didn't have it with us. So we're going to start at 12 o'clock this afternoon.
I'm staying
Back here. And we'll adjourn now.